Welcome to the Virtual Center for the Study of the Constitution of the United States. The Executive Director of the Virtual Center is Dr. Bill O'Brien. He's also your host. Now, here's Dr. Bill.
Welcome to today's program. This is Bill O'Brien, and you are tuned in to the Head On Radio Network and today's edition of the Virtual Center for the Study of the U.S. Constitution. It's a pleasure to be with you. I hope that your weekend was a wonderful one. I know we had some very, very serious weather issues in the Midwest, and we continue to do that as we speak. I know that we're having here in southern West Virginia, we're having, I think, a lot more rain than people expected we would get. There are isolated flood warnings up in a number of different places. We were predicted to have occasional showers, but these showers have become very frequent and much heavier than I think a lot of people anticipated. So we're kind of in that period, weather period, and of course, let's be honest, we really don't know what's going on with the weather anyway. So you know, we hear from our cynical brethren that the scientists are all wrong, and that the universe is going to be fine and everything takes care of itself, and we don't have to worry about anything that we do in the environment, because to think that we would have the power to affect climate is the kind of human arrogance that good Christians have been downplaying for a long, long time. So anyway, we won't go into that. It's kind of connected to the Constitution, but that's a little bit of a stretch, so we won't go there today. It's a pleasure to be with you today, and let me begin by encouraging you to participate actively in our program. We would love to hear from you on the topic that we'll be in, and I'll kind of run through a little bit of an agenda in a moment. But if you have an issue based on a past program or based on a program that you think we should address, by all means, I would love to hear from you. We would love to hear your perspective on it. I know our listeners would as well. It would give them a break from listening to me. And chances are, if it's an issue that it might be stuck in your craw, it's probably stuck in other people's as well. So please don't be hesitant. We would love to hear from you. The number to put you on the air is area code 304-658-3333. That's area code 304-658-3333. And if you'd like to email me directly on today's program, a comment or a commentary or a criticism or suggestion or whatever, or, in fact, a previous program, would love to hear from you. And I do commit to the idea that I will read your emails and respond to you. My email address is waobrien906@gmail.com. That's all one word, waobrien906@gmail.com. Been looking at a number of different issues and kind of scoping out exactly where we might go this week, and I thought I'd take a moment at the beginning of today's program and talk about some of the issues that I think are on the immediate horizon for us. And if you would like to weigh in on this as an agenda and suggest maybe something else or a comment or commentary on the issues that I am about to mention, then by all means we would love to hear from you. And again, the number 304-658-3333. If you will recall, the last time we were together here at the Virtual Center, we were looking at an article from the Ashcroft Center at Ashland University in Ohio on the Constitutional Convention, on the framers at the Constitutional Convention. And the title of the article was, if you recall, An Assembly of Demigods. And that's a phrase taken from Jefferson's commentary from across the oceans while the convention was going on, and he made that comment that when he saw the the rundown of who was there representing the different states, he made a comment that it was indeed an assembly of demigods. And the author of the article that we looked at last time we were together took that article, took those four words, an assembly of demagogues, and used them. As you recall, we got into the issue of straw men and various other things. But there's no question, just to kind of refresh your memory a little bit, that the purpose of that article was not to address Jefferson's thinking or commentary on the character or the nature of the Constitutional Convention and the men who were sitting in it. Rather, it was an effort to take on the concept of the living Constitution, and Jefferson's four words about the Constitutional Convention were a way to do it. And if you remember, the author of the article, Michael Schwartz, historian at Ashland University, the author of the article contrasted Jefferson's very positive outlook towards the convention as an assembly of demigods and contrasted it with what he felt was the very cynical look at the Constitutional Convention adopted in 1913 by Charles Beard in his economic interpretation of the Constitution. And in that article, according to the author, Michael Schwartz, Beard had criticized the convention's delegates as being self-interested, as being a cabal of propertied elites, and basically suggested that Beard's approach to the framers of the Constitution were that they were self-interested, racist, sexist, dead white men whose achievements and attitudes toward government should no longer concern us. And that was essentially the dichotomy that Michael Schwartz set up. And then he talked about the much more attractive option of choosing to look at the Constitution from the optimistic, positive viewpoint suggested by Jefferson, as the convention being an assembly of demigods, as opposed to the much more negative, cynical approach to the framers that Beard took. There's no question that in thinking about our last program and thinking about this, and we spent quite a bit of time on that article, and we had, if you remember, focused on Charles Pierce's piece in Esquire entitled "The History as an Explosive," the idea of the weaponization of history, and Pierce's argument that only one side was looking at it that way, and that the debate over the Constitution in today's world was very, very skewed because only one side was looking at it as a real contest, as a history as a weapon. The other side was looking for an opportunity to find compromise or common ground or whatever you wanted to call it, and the result was that there was a struggle going on, but only one side seemed to know that it was going on, and we talked a little bit about that as well. Clearly, one of the issues that surfaces from that particular program, from our last program, and seems to scream for a little bit of attention, a little bit more attention, is Charles Beard's economic interpretation of the Constitution. It seems to me that one of the issues that we really must take on, and it seemed to be, the situation seems to scream for it in light of the last program, our last time together. We do need to look, it seems to me, at Beard's economic interpretation of the Constitution, exactly what his position was. I think we really have to take on the issue of cynicism, negativism, self-interestedness, nature of the framers, all of it. I think we really need to do that. I've made, some references to that approach during our time together, but we haven't really looked specifically at Beard and at those who criticize Beard. And of course, Michael Schwartz is one, but he's only one. There are many. What intrigues me about this, I'll be very honest with you, is that in a sense, Beard is a little bit like Karl Marx. Since Karl Marx put together the manifesto in 1848 with Friedrich Engels, critics, opponents, those who read Marx in horror because of the tremendous power of his analysis of free enterprise Western capitalism during the Industrial Revolution, have tried every way in the world to deny Marx, to repudiate him, to criticize him, to do a lot of things. But the fact of the matter is, it's a little bit difficult to find anyone who has really successfully refuted Marx. People have repudiated him and attacked him and denied him and challenged him. But as far as being able successfully to prove that Marx's analysis is wrong, I suggest to you that hasn't happened yet. And the part of the reason is that there's quite a bit of validity. Obviously, there are issues in Marx that it seems to me have caused people problems, supporters of Marx especially. There were things about Marx that were very questionable. The fact that Marx believed that these kinds of things were inevitable and that mankind basically was a victim to the economic system that he found himself in, and that ultimately what you could almost predict the future as being almost absolutely without question, absolutely 100% right on. The implication being that there was nothing man could do to alter the political system in which he found himself. That, in other words, capitalism was so strong and the ingredients of it were so intrusive and so embedded in our Western capitalist system that there was nothing we could do but ultimately fall victim to the predictions that Marx made. And we know that a lot of predictions that Marx made did not pan out, did not come true. But again, as far as the economic analysis is concerned, we continue to await the person who can successfully refute that. I find a very, very similar situation with Charles Beard. Historians, American historians, especially historians of the founders, obviously many of them were appalled when Charles Beard's economic interpretation of the Constitution was published in 1913. One of the most famous critics of it at the time was William Howard Taft. As you know, Taft is going to become Chief Justice of the Supreme Court in the 1920s. At the turn of the century, he was governor in the Philippines. He came back, is considered among conservatives today to be a very viable voice in his analysis, especially in his role as Chief Justice. And he took on Beard directly and immediately. And, I think it's very, very revealing to know that one of the reasons that Taft believed that it was necessary to take Beard on as quickly and as directly as he did is because he felt that Beard was besmirching the sanctity of the document that the framers created in Philadelphia in 1787. And I really believe that that requires a little bit of contemplation. I think we need to pause on that one for a minute. In other words, it's not the fact that Beard's analysis was questionable. What bothered Taft as much as anything was that it tended to introduce a note of self-interest into the framing of the Constitution when those most supporters of it, and I think you could consider Taft to be one of those, believed that the Constitution of the United States was the product of some experience that happened in Philadelphia in 1787 that was somewhat spiritual, somewhat religious. It ties in with the idea of what we hear today all the time about American exceptionalism. The idea that many people want to believe that the Creator is behind our political system, and that somehow the hand of the Creator was all over the Constitution, the document framed in Philadelphia in 1787. The implication of that, of course, is that there were not politics and political issues involved. And so if you read the debates, Madison's notes on the debates of the Constitutional Convention in 1787, you begin to realize the degree of disagreement and the basis for negotiation and compromise that was called for, and the fact that on more than one occasion it was pretty clear that there was a real danger that the Constitutional Convention would collapse because certain members were threatening to leave over particular issues. Of course, the big one being the South and its interest, its felt need to protect slavery from a government whose power was being enhanced. The more the debates went on about the Constitution, the more power the new federal government clearly was going to have. And the idea is that as the power of the federal government increased, in the eyes of those who defended slavery, the vulnerability of slavery increased, its vulnerability increased proportionately as well. And so there was a real concern among Southern delegates especially of finding ways to protect the peculiar institution from a government whose power is being enhanced in this document that is being debated in Philadelphia. The point I'm making is many people choose not to get into any of that political negotiation or disagreement or whatever because they want to maintain the illusion that the hand of God was really behind that convention and what it produced. And consequently, that discord and disagreement and political negotiation and compromise and all the elements of human political negotiation and compromise, many people would prefer that it not be talked about at all. And I would suggest that that's kind of the way William Howard Taft went at Charles Beard, that his major agenda, his major goal was to attack Beard because he attacked the document, because he attacked the intent of the framers. And that was considered to be, something approaching a sin. And given the efforts at promoting, socializing Americans into this political system, into this republic that the founders created, it was a direction in which the William Howard Tafts of the world didn't want the conversation to go, is to get into the internals, the innards, if you will, of the debates and the conflicts that marked the Constitutional Convention. It's kind of like in a sense, and I'm drawing an analogy here, it's kind of like the debate over independence itself. The William Howard Tafts of the world are very comfortable with the imperialist approach to American independence. You know, they like to believe what Jefferson wrote in the Declaration, that if there's a culprit, if there's a culprit behind the movement, the war for American independence, it's Britain itself, it's Great Britain. And that what the colonists were doing were protecting their inalienable rights from a government that had become so all-powerful and so willing to violate the terms of the social contract, the limited nature of government, John Locke, that the founders really had no option, no choice. They were kind of pushed into a corner, and they had no choice but to declare independence, and that's the point that Jefferson made. Well, once you get the so-called progressive school of the American Revolution, progressive historians, one of whom, a major one, is Charles Beard, but the first one is Carl Becker. And Carl Becker's study of New York politics at the time of independence suggests that there's much more behind the decision to go for independence than what England was doing. In effect, what England is doing is merely playing into the hands of those who are pushing for independence for a lot of other reasons. Carl Becker is the author of the famous quote that there were two revolutions going on. One over who will rule at home, one over home rule, whether power will be within the colonies or power will remain with the mother country 3,000 miles away. So one of the revolutions is the struggle for home rule. But the other one, Becker says, is the struggle within the colonies themselves over who will rule at home. This is the internal revolution that we talked about, Merrill Jensen and many of the other progressives. And Carl Becker made the point, again, that there are two revolutions going on, one over home rule, the other one over who will rule at home. And his position is, if you have to make a determination as to which of those two revolutions is the most important, he believes that the most important revolution going on is the one going on within the colonies. In other words, what Becker is suggesting with his study of New York is that there's an awful lot of insight and an awful lot of information to be discovered and insight to be gained by looking at the internal story, the internal political situations going on within each colony. And once you do that, you begin to discover that there's a lot more behind the decision to go for independence than meets the eye. And those who don't want to get into that at all, those who want to continue to perpetrate the illusion that the story of American independence is the story of misrule by the mother country and the colonists' reaction to that misrule with the only option they had after being forced into it, which was a Declaration of Independence. That's very popular. That's the one that many, many folks would like people to buy into for a lot of reasons. It's conducive to the idea of white hats and black hats, the idea that the villains wear the black hats and the good guys wear the white hats. It's a story that is easily sold to young people, to children, because it's tailor-made to a similar breakdown between the good guys and the bad guys, between the white hats and the black hats, between the forces of good and the forces of evil, however you want to do it, however you want to describe that struggle. That's where many, many people would like to be. And that's where William Howard Taft is in his attack on Charles Beard. But again, I think it's important to recognize that while Taft has a brilliant mind, he is a brilliant constitutional attorney. He becomes Chief Justice of the Supreme Court in the early 1920s under President Harding. It is important to realize that while Beard has been attacked, challenged, ridiculed, rejected, denied, you pick the word, he really hasn't been refuted. Some of his research has been, because basically in 1913 he didn't have access to the sources that we do now. And some people have made their life's work going at Beard and continuing to pursue information that they can use to prove that Beard was wrong. Their goal is to prove Beard is wrong. It is not to learn what really happened. It is to prove Beard wrong. And I think that's very significant. That's what William Howard Taft's criticism of Beard is all about. Anyway, the point I'm trying to make, and I pretty well ate up the better part of a half hour on that, but that's one item, that's one issue that I think we really need to look into, is a much more in-depth look at Charles Beard and those who would criticize him. And that is a direct result of our last program. It seems to be that the situation is calling for that analysis. A second theme or issue that I think we need to try to take on this week, and I hope that we can do it, is the role of the Supreme Court under John Marshall, under Chief Justice John Marshall. There's no question that the power of the court as an equal branch of the three branches is a direct product of decisions on the constitutionality of legislation rendered by the Marshall Court, by John Marshall. And I think, usually you have to be careful, because when you talk about a particular court, you can say the Warren Court or the Burger Court, but you need to be careful, because the implication is that because the Chief Justice's name is associated with the court, that implies that the Chief Justice is always on the winning side, and that is not true. But in Marshall's case, it pretty much is true. One of the numbers that I can remember throwing out last week, they're so astounding that they're the kind of numbers that you don't forget. While he was Chief Justice from 1801 until he died in 1835, John Marshall participated in 1,127 decisions in the Supreme Court, and he was in the minority only 7 times. So in 1,120 of the 1,127 decisions in which he participated, he was in the majority, and he wrote, in most cases, he wrote the opinions. So basically, John Marshall and the Marshall Court are synonymous. And I think in that particular situation, we are correct in using the terms interchangeably, the Marshall Court and John Marshall by names, because in a sense, there's almost there's a symmetry there that is hard to reject. So I really think that, in light of the fact that we went through the Constitution last week and we looked at some of the most relevant parts of the Constitution, the Supreme Law of the Land Clause, the Contract Clause, the Commerce Clause, the Guarantee of Republican Government Clause, and others, it seems to me that we really are almost obliged to look at some of the major decisions of the Marshall Court, because it is in those decisions that the power of the federal government under the new Constitution is realized And it is also under the martial court that the power of the court itself is realized as one of three co-equal branches in this Republican form of government that the framers created in Philadelphia in 1787. And there's a third issue, and it's kind of connected to the second. And it's a particular issue that I've mentioned before because I've become very, very much involved with this. I find this issue to be very, very significant. And that third issue is the issue of corporations. The constitutionality of corporations. The role of the court, the right of the court, the right of government to incorporate businesses, both in the state and at the national level. And there are a couple of issues here which are related, and I think they scream for attention. And that's what we're here for. So let's do it. Let's make it kind of a game plan that in the course of the next few programs we will find a way to find time to address these issues and get into it. The first one is the nature of corporations themselves. And I think that's very significant. And the reason I say that is because I'm guessing that most of the people who are tuned in right now, the people who participate in our program, who listen regularly to the Head On Radio Network, are probably not corporate attorneys. And I know there are exceptions. There may be some attorneys out there. I'm not saying that there aren't. But most of us are not. I'm not. And so therefore, if you were an attorney, and you went to law school, chances are that part of your law school course of study was on the nature of corporate law and the nature of corporations and the rest of it. But those of us who didn't have the experience of law school have never encountered this before. There's no way in the world our history courses covered it, because the people teaching these courses probably didn't know it either, because they're not attorneys. And so the fact of the matter is, I have become intrigued with the whole idea of corporations, not only about their legal status, but more specifically, and this is where this will be familiar if you've been with us, because I've mentioned this more than once before, not so much because of their legal status as because of their personhood. The whole issue of corporations being considered legally under the Constitution as persons. And where this came to be, the reason that this came to be such an issue of late, stems directly from the 2010 Supreme Court decision by the Roberts Court on Citizens United. The right of corporations to make unlimited contributions to political campaigns and have those contributions considered as free speech, as political speech under the First Amendment. Because where this takes us is into the very, very mucky, blurred, gray area of the extent to which corporate persons are entitled to the protections of the Bill of Rights that living persons are entitled to. We find, for example, that corporations, corporate attorneys, have taken this idea of personhood from previous Supreme Court decisions and have begun to directly apply the Bill of Rights to these situations. For example, the Fourth Amendment to the Constitution and the Bill of Rights protects persons from illegal search and seizure. All through my life, and I'm guessing through your life as well, we believed that that amendment meant that government agents couldn't come crashing into your home and search your home for things that might be illegal in it. We believed, and television programs teach us this, don't they? Law and Order teaches us this. Matlock teaches us this. Jessica Fletcher taught us this, that your home is your castle. Jackie Gleason used to teach us this, that my home is my castle. And what that means is, in order for government to come in, they needed a search warrant. And there had to be an expectation of criminal intent, criminal activity going on. The state couldn't just crash in and start looking around. There had to be a reason. They had to be after something. And how many times have we seen evidences in programs or movies we watched about evidence being thrown out of court because it was illegally seized? The people were not served with a search warrant. They were not given prior notice. In a sense, their castle was invaded by government, which is a violation of the Fourth Amendment. That's what I grew up believing the Fourth Amendment was about. Now we find, under the issue of corporate personhood, we find that corporations are refusing to give government documents and records, corporate records, under the idea that as persons, they are protected by the Fourth Amendment search and seizure provisions as well as our living persons. And so it's very, very interesting that the courts are into this. And it's clearly going to get bigger and bigger and bigger. For example, one of the issues, we are all familiar with the Fifth Amendment against self-incrimination. How many times have you heard stories about people refusing to answer questions because they didn't want to incriminate themselves? So far, the courts have refused to extend Fifth Amendment protections to corporations, arguing that they are not exactly living human beings, they are not exactly persons, they are not exactly the same. So therefore, the argument was the Fifth Amendment was intended to protect individual citizens against self-incrimination. And the argument was that right ought not to be extended to corporations. So far, the courts have been reluctant to extend Fifth Amendment protections to corporations. But they've been playing around very seriously with the idea of Fourth Amendment protections as corporations refuse to turn over documents and relevant information of the corporation to government agencies like the IRS. And of course, we know what's been going on over the last week to 10 days as far as the IRS is concerned. So the damage that this particular IRS situation is going on right now, the damage that that's likely to cause down the road in terms of government's ability of oversight and regulation of corporate behavior, it seems to me to be very, very relevant and very, very significant. My point is, this is an issue that I think we need to explore. It's clearly related to the Constitution. A virtual center on the study of the Constitution can't avoid it. So we have three basic issues, it seems to me, that are kind of all screaming at the same time for attention. First is Charles Beard. The second one is the Marshall Court and filling in kind of the blanks, if you will, and enhancing the potential power of the Constitution for the federal government under specific clauses of the Constitution. And, of course, the key one in terms of enhancing federal power is the very famous necessary and proper clause in Article 1, Section 8, I believe. And the third one is the whole nature of corporations. And so, you know, it's kind of, you know, a draw here as to which one we do first. I would kind of like to move a little bit into the Marshall situation a little bit and look at some of the Marshall decisions, because we kind of left this issue open. We looked at these various clauses under the Constitution where the courts were going to zero in and define much more precisely the powers that government had vis-a-vis the federal government and the state governments. And we kind of identified them as we went through the Constitution last week, and then we left the issue hanging. So it seems to me that a first issue ought to be the Supreme Court and the role of John Marshall. And the first one, the first case that I would like to address, and I don't want to spend a whole lot of time on this because I don't think it's very significant for what it potentially means. It's always in every single textbook on American government, American history, and the experts consider it to be a major case. The fact of the matter is, you know, I think legalists would agree that the case of Marbury versus Madison is probably kind of a trumped-up case. And what I mean is, it's not a really significant issue, but it's what Marshall wants in order to render the decision he wants to make. Marshall's intent in Marbury versus Madison is to exert the power of the court. That's what comes out of Marbury versus Madison. The case itself is not very significant. I'm not going to go, I can go through a little bit, just an overview for it. If you remember when John Adams was President of the United States, 96 to 1796 until 1800, and then in the very famous election of 1800 between John Adams and Jefferson, Jefferson is elected President of the United States in what the textbooks refer to as the election, as the Revolution of 1800. And if you go into details as to why historians like to paint Jefferson's election in 1800 as a revolution, the answer is because this is the first time in history that power has transferred from one party to another party without violence. The election of 1800 is the transfer of power from Federalists to Jeffersonians without the violence of revolution. It's kind of evidence, proof positive, that our electoral system under the Republic that the framers created in Philadelphia in 1787 can work. It seems to be, I think people would agree with this, when the Constitution was drafted, there was every expectation in the world that George Washington would be the president. If there was a reason why so many delegates at Philadelphia were not as concerned about the power of the executive branch, the power of the presidency, as they probably ought to have been, it was because most people assumed that Washington would be the first president. And everybody trusted and loved George Washington. If you think about it, Washington voluntarily gave up his military power after independence was won. He basically disbanded his army and went back to Mount Vernon. He was the first political leader in the modern world who had political power and voluntarily gave it up. People trusted him. And there was general belief that he would be the first president under the Constitution. And while there was debate and concern about the power of the executive branch in the Constitution, it was not nearly as heated, the debate was not nearly as heated as it would have been had Washington not been there. Of course, to be very honest with you, there's a whole string of letters, series of letters, about getting Washington to go to the convention in the first place, because George Washington and Hamilton, among the two, Madison believed that if Washington didn't go to the convention, chances are that the convention would be a failure. It was the prestige and the trust in the person of George Washington, as much as anything else, which made the convention a success and basically made it possible for the kind of compromises to go on at Philadelphia that did go on. There was a lot less likelihood that delegates in mass would bolt the convention because Washington was there and people trusted Washington. My point is that Washington was the first president. He was inaugurated in 1789. 4 years later, he was reelected unanimously in 96. In 94, rather. And in 96, Washington chooses to not run for a third term. And it turns out that his health is failing, and Washington will not live to see the election of 1800. But I believe, and I think most people would agree, that if Washington was younger and in better health, chances are he could have been reelected for president as many times as he wanted to be. Kind of like FDR. He was trusted that much. So the election of 96 becomes a critical one because it's an election between John Adams and Jefferson principally. And John Adams is elected president, and because he got the second highest number of electoral votes, Jefferson is elected vice president. And how inconvenient is that? A totally different party. And then, of course, comes the election, the revolution of 1800 with the election of Jefferson. When Jefferson wins the election of 1800 and is scheduled to take over the White House early in 1801, John Adams and the Federalists availed themselves of the opportunity to make all of these last-minute so-called midnight appointments, principally to the courts. To use the term which a lot of people use, Adams packs the judicial system, packs the courts with Federalists. The assumption being that while Jefferson has been elected president, and while the supporters of Jefferson are going to control Congress, the Federalists can still be in control of the judiciary because of these appointments. Under the Constitution, federal judges are appointed during good behavior, which means, barring the fact that they are impeached, they serve for life. And so Jefferson is forced to live with a court system that is packed with his opponents. And one of them is John Marshall. And what makes the issue very serious is that there's not a whole lot of expectation at the time that the courts are going to have much to do. In fact, John Jay was the first Chief Justice, and he left because he felt like there had to be something more important. So John Jay becomes a court official in his home state of New York, because he feels like there's much more going on in the state level than there is in the national level as far as the judicial branch is concerned. And he's replaced by Oliver Ellsworth. Not Oliver Ellsworth, excuse me. God, I'm stuck for a name. Anyway, he's replaced by another temporary replacement. So actually, John Marshall is the third Chief Justice. But he seizes the opportunity under the case of Marbury versus Madison to enhance the power of the courts by asserting the right of the court to rule on the constitutionality of state laws under the idea of judicial review. And the basic premise of the whole thing is that Madison was Secretary of State. Marbury was given one of Adams's midnight appointments, and Marshall was Secretary of State, and Marshall did not deliver the appointment. And after Jefferson came in and Madison became Secretary of State, then Marbury went to court demanding that as Secretary of State, Madison deliver his appointment. And Madison refuses to make it, and it goes to the courts in the case of Marbury versus Madison. And in that very famous case, Marshall asserts the right of the courts to interpret the constitutionality of legislation. In this case, he basically argues in his decision that while Marbury has a right to the appointment, the law that requires Madison to deliver it is unconstitutional. And so what you have is a situation where Marshall obviously would much prefer that Marbury be appointed, get his appointment. His political druthers, his political preferences would be that Marbury is appointed. But the opportunity to basically render power to the role of the Supreme Court is a much more attractive option for Marshall. So he uses the opportunity to expound on the right of the court to rule on the constitutionality of legislation by saying that while Marbury has every right in the world to his appointment, the law which requires Madison to deliver it is unconstitutional. The point I'm making is, in the history of the nation's politics, that particular issue is not very big. It's not very, the earth doesn't shake and rumble over whether Marbury gets his appointment or not. It obviously matters to Marbury and those close to him. But in terms of the direction of the nation, whether he gets his appointment or doesn't get his appointment is not really a big issue. But Marshall's assertion of the role of the courts to rule on the constitutionality of legislation is significant. Because beginning with that decision, Marshall has put the nation on alert that the court is a branch of government to be reckoned with. And from that point on, Marshall begins to speak for the court in making interpretation after interpretation after interpretation of legislation, which is in a sense highlighting the key elements of the Constitution, which by inference, by implication, will enhance the power of the federal government at the expense of the states. In my mind, this is just my own opinion, but in my mind, there's no question that Southern delegates would have walked out if they had had any idea of the power that the federal government was going to be given under rulings of John Marshall. The kind of power that John Marshall finds ways to deliver to the federal government in the way he interprets the Constitution of the United States was the kind of power that the Southern delegates were really afraid of from the very beginning because of their felt need to protect the institution of slavery. And if they had had the kind of inkling as to what Marshall was about, Marshall was a Virginian, of course. He was a Southerner. And I don't think the South, as a section, had any expectation in the world as to what the overall impact of the Marshall Court was going to be on the relationship between the federal government and the state governments, so-called federalism, the American federal system, the division of power between the states and the federal government. Most Southerners bought into the idea that while the Constitution created a federal government with much more power than the central government had under the Articles of Confederation, most believed that the overall structure of government would remain pretty much the same, i.e., that the states would remain in most areas predominant. And I think the first years of the Constitution's life under the Chief Justiceship of John Jay, and I believe it's Ellsworth, but I'm not sure. It's Connecticut anyway. The second Chief Justice is from Connecticut. I believe it's Oliver Ellsworth, but I'm not really sure. And then the third one is Marshall. But Marshall changes all of that, and I think it's very, very significant. So the Marshall versus Madison case is very important for the power that it leaves in the hands of the courts to interpret the Constitution. And the point I would make, and I think this is significant, most people give the Marbury versus Madison decision much more attention than it probably deserves, because very honestly, most of the framers at the Constitutional Convention believe that that's what the courts do, is basically explain what the law is. The courts render decisions on the meaning of law. That's what courts do. That's what they did in Great Britain. And so the idea that the Supreme Court would do this was not a revolution to most of the delegates. Hamilton, there's all sorts of evidence in speeches and statements that Hamilton made at the Constitutional Convention that he fully expected the Supreme Court to fulfill this role, which is basically say what the law is, what the Constitution is about. So I don't personally believe that Marbury versus Madison is as significant as many people do, because I think most people who are in the know knew it anyway. But Marshall, in that decision, uses a rather minor political issue as an opportunity. He seizes the moment to make a decision that ratifies once and for all the power that the court is going to have in this republic. And I think it's very significant. We are at the top of our hour. We just completed 1 hour. We have 1 hour to go. It's time to let's pause and take a 3 or 4 minute break and stretch a little bit and we'll come right back and we'll do our second hour. You joined the Virtual Center for the Study of the Constitution. I'm Bill O'Brien, and we'll be right back. Thank you, and it's a pleasure to be back with you for this, our second hour. It's 5 minutes after the hour, and if you were with us during our first hour, we thank you for staying with us. And if you are just joining us, welcome to this second hour of the Virtual Center for the Study of the Constitution. Our phone number, and we invite you to participate actively in our program, in the discussion. Our phone number is area code 304-658-3333. And my personal email address, if you'd like to email me on this program or previous ones or future ones, whatever your preference, by all means, feel free to do that. My email address is waobrien906@gmail.com. That's waobrien906@gmail.com. And again, the phone number, 304-658-3333. And before we get back into the material we were talking about, I want to make a comment which I want everybody to think seriously about, and I mean that. I want to thank the Bob Kincaid, the folks at the Head On Radio Network on the Horn, for putting a program like this on the air. This is not, this is not a money maker by any stretch. I think we all know that. But I am indebted to the network and to Bob Kincaid personally for giving us the opportunity to be with you a few hours, 3 days a week, to discuss aspects of the Constitution. In our first hour today, we looked principally at some of the issues that are screaming for attention, and we spent the last portion of our first hour on the Marbury versus Madison case. And, a lot of it is content-based, but very honestly, a lot of what I have to say about it is my own personal opinion. I am not an attorney, but I believe in the history of relevant Supreme Court cases. I personally believe that Marbury versus Madison is one of the less significant ones, at least for the issues involved. But I think the result of it, the decision itself, is significant because it ultimately establishes the right of the courts to interpret the meanings of the Constitution. But I would point out that that's something that most attorneys at the time and a number of the members of the Constitution Convention were indeed attorneys. And I think it's something that many of them were fully aware of anyway. I know Madison made that comment, as well as did Alexander Hamilton. Hamilton, on more than one occasion, made reference to the fact that he fully anticipated that the idea of judicial review was something that the courts always do throughout the history of England and the British Constitution. It was the courts that gave meaning to the unwritten British Constitution. So I think that's very, very significant, because the courts traditionally in Western jurisprudence defined exactly what the law is and what it meant and what its implications were. And that's indeed what Marshall is doing in Marbury versus Madison. The point I would make is that it is very, very important for a program like this to be available to the listening public, without getting into the political issues that we were into last time about articles and positions for the right of the left and setting up straw men and all of these things. The fact of the matter is, I think we're going to find before this hour is done, we're going to begin to appreciate the extent to which getting into the sources themselves is vital in order to understand the meaning of the Constitution, which is what the whole idea of the Virtual Center is about. I think it's absolutely incredibly important. And I think we all owe a debt of gratitude to the Horn, to Bob Kincaid, and to those of you who have joined in to help keep programs like this and a network like the Head On Radio Network on the air. I think it is absolutely vital that we do that. So I would encourage all of you, if you are inclined and you do appreciate programs like this, then if you can find a way to help out the Horn, the Head On Radio Network, if you go to the headonradionetwork.com website, there's a PayPal opportunity there where you can make a donation to help Bob and his folks keep this network on. It's very important in our political dialogue today that what this network stands for, and what this nation stands for, very honestly, remains viable and credible, principally because people have the opportunity to hear points of view like this expressed. I think it's very important, and I hope that you will all take this seriously. I know that I do, and I appreciate so much the opportunity to be here with you. There's absolutely no question that, as I mentioned in the last hour, we were talking about Marbury versus Madison, that some of the decisions of the Marshall Court are absolutely critical. But one of the things that I found, and I prefaced that, the first word in my sentence there was but, and I want to emphasize what I mean by that. Oftentimes, we find ourselves vulnerable to what people who have a political agenda tell us things mean. And there's absolutely no question that some of the major decisions of the Marshall Court fall into that category. Every textbook, if you pick up an American history textbook, it's going to have a portion of a chapter on the Marshall decisions, because the role that the Marshall Court plays in enhancing the power of the federal government, which is ultimately going to bring on, one of the issues that's going to bring on the Civil War, there's no question, is the power of the federal government that John Marshall is personally responsible for making sure the government has. These decisions are critical. And every textbook has a section, a portion of a chapter, which will go through the very famous decision, most famous decisions of the Marshall Court. Fletcher versus Peck, McCulloch versus Maryland, Dartmouth College, the very famous Dartmouth College case, Dartmouth College versus Woodward, Cohen's versus Virginia, and a number of other issues. That what happens to the nation under the Constitution during the Marshall era is critical, because the role of government in leading and directing and fulfilling the charter outlined in the preamble to the Constitution almost requires that government be able to do the kinds of things that Marshall gives it the power to do in the way he interprets the Constitution. And the point I would make is that our textbooks go into many of these cases in detail. And I want to address a few of these myself. But I want to preface this by saying something else, which I think is significant. What I am finding is that there's much more to be learned in these Marshall decisions than the facts of the case dictate. I would suggest to you, and the one I'm going to get into in a moment, is McCulloch versus Maryland, which is the very famous case on the constitutionality of the United States Bank under the economic program of Alexander Hamilton. McCulloch versus Maryland, 1819, is one of Marshall's most famous cases. And most people know it as the case that ruled in favor of the constitutionality of the United States Bank. People who know the period pretty well will recognize that Marshall's decision in McCulloch versus Maryland pretty much borrows directly from the rationale of Alexander Hamilton when his economic program was first put out there early in the Washington administration in the 1790s. You will remember that, very briefly, that one of the elements of Hamilton's economic program as Secretary of the Treasury, Congress, under President Washington, the Congress asked Alexander Hamilton, as Secretary of the Treasury, to bring forth a series of economic proposals to get this nation on a positive, proper footing economically. And Hamilton issues a series of reports, a report on manufacturing, a report on commerce, a report on a number of reports on a number of other things. And Hamilton's program lays out a very specific set of agenda items that he wants the Congress to do in order to get this nation off on a proper footing. And one of his major proposals is for the creation of the United States Bank. And immediately, the bank proposal runs into opposition from, among others, James Madison. Now, one would think that James Madison, as the author of the Virginia Plan at the Constitutional Convention, would not oppose giving the government the power to charter a bank, a national bank. But he does, because for a number of reasons, Madison is an American, but he's also a Virginian, and he's a prominent Virginian, and he's very, very suspicious of Hamilton and the power that Hamilton chooses to give the new government, etc. We won't go into that's the beginning of the two-party system in American politics. But the point that I would make, which I think is very, very significant, is Hamilton makes the point in response to Madison that while the Constitution of the United States does not give Congress the power to create the United States Bank, it does give Congress the power to create that bank under what Hamilton calls implied powers. Powers which are not there in black and white, but are inferred or implied by the powers that the government does have. And Hamilton makes the point Congress has the power to tax. Congress has the power to collect taxes. Congress has the power to regulate trade. Congress has the power to collect tariffs on goods coming into the United States from overseas. And Hamilton's position is, if government is going to fulfill the specific economic powers that the Constitution gives it under Article 1, that it stands to reason that government would need the power to create a bank in order to manage this whole process. And the issue between him and Jefferson as Secretary of State at the time, the issue goes to the desk of George Washington, the President. And Washington finds in favor of Hamilton and his argument for the constitutionality of the United States Bank. And the bank is chartered up until the charter expires in 1811. And one of the things that happens just prior to the War of 1812 is that the charter is not renewed. And the bank is allowed to go under, to go out of existence in 1812. It is very relevant, very significant, that when the War of 1812 ends in 1816 and Monroe is President of the United States, Madison himself comes forth and recommends the chartering of a second United States bank because he realizes in the 4 years that the nation does not have a United States bank, the tremendous economic problems that lack of a bank will create. In other words, Madison becomes a supporter, ultimately, of the position that he opposes in the early 1790s when he opposes Hamilton's bank. And the constitutionality of the second bank goes before the Supreme Court in the case of McCulloch versus Maryland, and Marshall issues that very famous decision in 1819. And this is just straight out of the textbooks at this point. Marshall makes the point that the so-called necessary and proper clause in Article 1, Section 10, Congress will have all the powers laid out, spelled out, it's Section 8. Congress will have all the powers given to it in Section 8, the power to tax, the power to regulate trade, etc., etc. And then the last power in that section is Congress will have the powers necessary and proper to carry out its previous powers. Therein lies the so-called right of implied powers. Therein rests the legitimacy, the constitutionality of the United States Bank. And in the case of McCulloch versus Maryland, Marshall rules in favor of Hamilton's position of the 1790s. On the right of government to create the bank. And the phrase, the sentence that is frequently quoted in most of the textbooks from McCulloch versus Maryland says the following: let the end be legitimate. Let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited but consistent with the letter and the spirit of the Constitution, are constitutional. This is the very famous line from Marshall's decision in McCulloch versus Maryland. Let the end be legitimate. Let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited but consistent with the letter and spirit of the Constitution, are constitutional. John Marshall is saying that the bank is constitutional under the necessary and proper clause because if the goal, if the end is legitimate, if the end is not unconstitutional, if it is within the scope of the Constitution, and if it is not prohibited by the Constitution or by the spirit of the Constitution, then it's legal. The Congress has the power. So it's a very broad interpretation of the legitimacy of the Bank of the United States. And that is the position that the Marshall Court is famous for in the case of McCulloch versus Maryland. Very significant, because it gives credibility, it gives teeth to the necessary and proper clause, which is in the Constitution. Many people saw it and wondered what its potential power might be. Marshall is basically laying out exactly what the full potential of federal power vis-a-vis the states might be under the Constitution. But what I would like to share with you is the part of McCulloch versus Maryland that most people ignore. Because when Marshall takes the case, he opens his decision with the question, has Congress the power to incorporate a bank? And he challenges those who argue that the power to incorporate corporations, to create corporations, is a state power, not a federal power. What am I saying here? What I am suggesting is that McCulloch versus Maryland is a much more important case than history treats it, because it legitimized the constitutionality of the United States Bank. It recognizes that not only is the bank a bank, it is also a corporation. And what Marshall is doing here is using this case to legitimize the right of Congress to create corporations. And given the discussion we just had in the previous hour about Citizens United and about the power of corporations in today's world, the potential of Congress's power to create corporations is going to end up at least as important, if not more so, than the power to create a bank. So therefore, what Marshall says in McCulloch versus Maryland, not about the bank, but about the power to create corporations, is potentially more important to the history and direction of this nation than most people have ever assumed it to be. I believe that the power to create corporations and what that's going to mean long term is going to be more significant than the bank itself. Most people focus on the bank because of the political issues involved with the Jeffersonians and the idea of implied powers. And that is important. Please, I'm not saying that it's not. But I would suggest to you that the groundwork that Marshall is laying in this decision for the right of government to create corporations in order to fulfill its charge under the preamble to the Constitution is at least as important as is the right to create a particular corporation, namely the United States Bank. I would ask you to think about that. And I would like to share with you some of Marshall's reasoning here, where Marshall is going and what he is saying. Up until this point, the right to incorporate businesses, to create corporations, was a state power. It goes all the way back to the colonial period and the right of colonial governments to charter corporations. And under the Constitution, the states are passing laws of incorporation. Now, what do laws of incorporation mean? When the state constitution gives you as an individual or a group of investors the opportunity to go through the state and be given a charter of incorporation, it involves the right of limited liability. What that means is that the money that you are investing in the corporation can be lost if the corporation fails. But by limiting your liability, it limits what you can be sued for if the corporation fails. Let me try to explain this in another context. If there were not laws of incorporation, if there were not limited liability laws, then investors would be reluctant to invest because they would potentially be liable for everything they have if somebody sued their company. You could lose your home. You could lose your retirement. You could lose all of your insurance. You could lose everything if somebody sued your company in court and won. You would need a lot more than Matlock to come out alive financially from a suit like this. Government realizes that if business is going to grow, if economic development is going to happen, then people must be encouraged to invest in economic expansion and economic growth. How can you expect investors to invest when they remain liable for everything they have and everything they own if their investment fails? So what government does under limited liability legislation is limit the investments and limit the liability of the investors to the company itself. By protecting the investment from suit, from liability, government is making investment a lot less risky. It's making people a lot more willing to invest in capitalism, to become stockholders in companies. Everybody knows that the profit potential is there, but so also is the liability. If government can step in and limit the liability, then the combination of the profit to be made from success and the dangers of failures being reduced serves to make the environment for investors much more positive, much less risky. And later on, when the tax laws begin to give investors reduced tax liability on investments, things like capital gains and all the rest of it, then what government is doing is making investment and free enterprise much more lucrative for investors. What makes this politically very explosive is the fact that most people don't have the capital necessary to take advantage of these kinds of legislation. This is the kind of business-friendly legislation that investors and corporations have been benefiting from since the very beginning. It is very significant in light of what laws of incorporation are about. It is very significant that John Marshall, is claiming the same rights of incorporation for Congress, for the federal government, as the states are presumed to have within their own borders. There's no question on the part of the founders that state governments will have the right to charter corporations and to limit their liability. That's what economic growth is about. That's what the partnership between business and government is all about. So by passing laws through legislatures, through business-friendly legislatures, which make investment lucrative and reduce risk proportionately, government is doing its part to stimulate economic development. That's what economic growth is about. John Marshall is claiming that right for the federal government as well as the state government in McCulloch versus Maryland. He is using the issue of the constitutionality of the United States Bank to claim the right of Congress under the Necessary and Proper Clause to charter corporations and to protect corporations and to stimulate investment and stimulate growth by creating new profit centers for investors. It's a very business-friendly, investor-friendly environment that Marshall is creating and is laying out in McCulloch versus Maryland. So the first thing that Marshall has to do is he has to make the point that these laws of incorporation, the right to create corporations, ought not to be just state rights, but ought to be federal rights as well. And he takes on the issue of the questioning of the banks, the United States Bank, as a way to do this. And he points out that the Constitution itself, when it was written in convention, was submitted to the people. And he underlines the word people in his decision. They, meaning the people, acted upon it only in the manner in which they can act safely, effectively, and wisely on such a subject by assembling in convention. He's talking about the way the Constitution is ratified. In conventions of the people in each state. He says, it is true they assembled in their several states. Where else should they have assembled, he points out. No political dreamer was ever wild enough to think of breaking down the lines which separate the states and of compounding the American people into one common mass. Consequently, he says, the conventions met in the states, but that doesn't limit the power of the decision to the state governments alone. He says, from these conventions, the Constitution derives its whole authority. The power of the Constitution does not come from the Constitutional Convention that drafted it. It comes from the popular conventions of the people who ratified it. Marshall then says, the government of the Union then, whatever may be the influence of this fact on the case, is emphatically and truly a government of the people. In form and in substance, it emanates from them. Its powers are granted by them and are to be exercised directly on them and for their benefit. What Marshall is doing in McCulloch versus Maryland is going back to the way that the Constitution was ratified. Remember Madison's positions in Federalist Number 10 and Federalist Number 51. Since the Constitution is ratified by the people of the states, when enough states ratify, then the Constitution has been ratified by the people of the United States. That automatically renders each state into a minority status. Madison lays that out in the Constitutional Convention. Marshall is ratifying it in McCulloch versus Maryland. He is basically claiming the sovereignty of the people of the United States for the sanctity and superiority of the Constitution of the United States and the power of the government created under it. The people, as sovereign, created state governments, but when they ratified the Constitution in conventions within their states, they were using their sovereign powers to create a government superior to the states that they had created previously. So in McCulloch versus Maryland, John Marshall is laying out the groundwork which Abraham Lincoln is going to go to in 1861 when the southern states start to secede from the Union after Lincoln's election, claiming that the Union is a compact of free states. And Marshall is laying out here in 1819, no, it's not. The Constitution is not a compact of independent states. The Constitution of the United States is a national government created by the people of the United States in special conventions which met within the states for the purpose of creating a national government. And therefore, any state which seeks to break up this union is in rebellion. And that was Lincoln's position throughout on the nature of the Union in the 1860s. And for credibility and sustenance, he can go to the Marshall Court, which is laying that out in McCulloch versus Maryland. The point I'm making is this decision is about a lot more than the constitutionality of the United States Bank. It is laying the legal foundations for future decisions and future courts who will revisit it, this decision, in order to rationalize and justify the particular powers of the federal government that they are, seeking to justify. So Marshall says in a portion of this decision, if any one proposition could command the universal assent of mankind, we might expect it would be this: that the government of the Union, though limited in its powers, is supreme within its sphere of action. This would seem to result necessarily from its very nature. It is the government of all. Its powers are delegated by all. It represents all and acts for all. So what Marshall, I keep getting Madison and Marshall, I guess they're starting with the M. What Marshall is doing here is laying out once and for all the nature of the Union and the process by which it was ratified. Therefore, Marshall says, and it stands to reason, that he would go to that portion of the Constitution which says that this Constitution and the laws of the United States which shall be made in pursuance thereof shall be the supreme law of the land. The Constitution doesn't just say it. Marshall explains it and uses this case as a way to do it. He goes on about the issue of implied powers. Among the enumerated powers, Marshall says, we do not find that of establishing a bank or creating a corporation. This is the point I'm making. Notice, it's not only about the bank, it's about creating corporations. Marshall says, among the enumerated powers, we do not find that of establishing a bank or creating a corporation. But there is no phase in the instrument which, like the Articles of Confederation, excludes incidental or implied powers, and which requires everything granted shall be expressly and minutely described. This is critically important. Among the enumerated powers, among the specific powers granted to Congress, Marshall says, there's no mention of the power to create a bank or to create a corporation. But there's nothing in the Constitution, unlike the Articles of Confederation, which excludes the right to do this, which excludes implied powers. There's nothing in the Constitution which requires that everything granted shall be expressly and minutely described. And then he says this. Remember we talked about the 10th Amendment. Marshall says, even the 10th Amendment, which was framed for the purpose of quieting the excessive jealousies which had been excited, omits the word expressly. So he goes directly to the 10th Amendment and the absence of the word expressly. And he says, even the 10th Amendment declares only that the powers not delegated to the United States, nor prohibited to the states, are reserved to the states or to the people, thus leaving the question whether the particular power which may become the subject of contest has been delegated to the one government or prohibited to the other, to depend on the fair construction of the whole instrument. Because the word expressly is not there in the 10th Amendment, he says, that means that the whole issue is open to interpretation, and Marshall is implying that's what I'm doing. That's what the court is doing. It is interpreting the Constitution. It has the power to do so because the word expressly is not in the 10th Amendment. The men who drew and adopted this amendment had experienced the embarrassments resulting from the insertion of this word in the Articles of Confederation and probably omitted it to avoid those embarrassments. So Marshall is saying here that the omission of the word expressly from the 10th Amendment stems from the embarrassments of the Articles of Confederation, which the inclusion of the word expressly had created. But the key, I think, the key here is that the elimination of the word expressly from the 10th Amendment opens up the entire Constitution to interpretation by the courts. This is the soul, the heart and soul of the living Constitution. What Madison is doing right out of the chute here in 1819 in McCulloch versus Maryland is he is asserting, as he did in McCulloch in Marbury versus Madison, he is asserting the right of the courts to interpret the Constitution, especially in the area of implied powers. And to justify that, he is saying there is nothing in the Constitution which denies the right of government, of the federal government, to have implied powers. And the word expressly is not there. So therefore, the combination of those two facts means that the power of government under the Constitution is open to interpretation, and Marshall is claiming that right of interpretation for the courts. Wow. There is much more to McCulloch versus Maryland than the legitimacy of the Bank of the United States. This is a powerful, powerful piece of literature. And we have about 7 or 8 minutes left in today's program, so we'll continue this. But let me read you the next couple of sentences of this decision, and you can kind of think about it as we bring today's program to an end. Marshall says, a constitution to contain an accurate detail of all the subdivisions of which its great powers will admit, and of all the means by which they may be carried into execution, would partake of the prolixity of a legal code, and could scarcely be embraced by the human mind. If a constitution was to include every specific power that government was to have, it would blow your mind. It would be so long. It would be a legal code. It would not be a constitution. So Marshall is making a distinction here between a constitution and a code of laws. And he is basically suggesting that a code of laws spells out in detail what every law is. A constitution, however, can't do that because, as he says, it could not be embraced by the human mind. It would be so broad. Therefore, a constitution must leave specificity to interpretation. And that's what he's claiming under McCulloch versus Maryland, is the right to interpret. It would probably never be understood by the public. Its nature, therefore, requires that only its great outlines should be marked, its important objects designated, and the minor ingredients which compose those objects be deduced from the nature of the objects themselves. Marshall is making the case for the Constitution's general nature and vagueness. He is basically defending the fact that the framers did not specify the specific powers. By putting in a necessary and proper clause, by putting in a supreme law of the land clause, the framers opened the Constitution to interpretation and guaranteed that it would survive from generation to generation to generation, because it can constantly be interpreted and reinterpreted and kept up to date. This is prescient on Marshall's point. This is incredibly visionary. I ask you to think about the Michael Schwartz piece we considered last week about the positive nature of Jefferson's assembly of demigods, and the much more specific interpretive nature of the Constitution, which constitutes what we call the living Constitution. Marshall continues that this idea was entertained by the framers of the American Constitution is not only to be inferred from the nature of the instrument, but from the language. Why else were some of the limitations found in the 9th section of the first article introduced? The 9th Amendment says that the mere specificity of specific rights does not mean that there will not later be other rights added. The 9th Amendment is usually focused on as the basis for the living Constitution. I would suggest to you that Marshall's reasoning in McCulloch versus Maryland is greater support for the idea of a living Constitution than is the 9th Amendment itself. But Marshall includes mention of the 9th Amendment here. And he said if this wasn't true, why else were some of the limitations in the 9th article of the 9th section of the first article even introduced? It is also, he said, in some degree warranted by the having omitted to use any restrictive term which might prevent its receiving a fair and just interpretation. In considering this question, then, we must never forget that it is a Constitution we are expounding, not a code of laws. A code of laws would require specificity, A constitution does not. What is, going back to Madison's vices of the American political system, his concerns about the Articles of Confederation, his major concern, if you remember, was because the Articles of Confederation had changed and added so many laws that had constantly been overturned and new laws passed, that the constitutions became so long, so huge, so cumbersome, that nobody even knew what the law was. In effect, what Marshall is saying is that Madison's concern about the Articles of Confederation comes down to the fact that state constitutions had become more codes of law than constitutions. And he is defending the Constitution of the United States because the framers had the foresight to not let that happen. And that, I would suggest to you, is a key piece of the significance of the McCulloch versus Maryland decision. It is huge, not only because it legitimizes creation of the United States Bank, which is what our textbooks tell us, but more important, because of the nature of the union it defines, and because Marshall is claiming for the federal government under the necessary and proper clause, under the right to implied powers, the right of Congress to charter and create corporations, the right of the federal government to directly promote economic development, not at the expense of the states, but in conjunction with the states. And this further makes the relationship between states and federal power a little bit more complex, a little bit muddier, a little bit vague, a little bit more vague, a little bit cloudy, and much more vulnerable to interpretations by the court. As each case comes, as each new situation arises, the opportunity is there for the courts to look at the particular situation in light of the power that Marshall is claiming from the very beginning here in 1819. The McCulloch decision is a critically important decision. I'd like to continue with it in tomorrow's program. But right now we've reached 57 minutes after the hour. We need to give Bob Kincaid and his folks time to set up for the Bob Kincaid show this evening. So I'm going to basically suspend our virtual center programming today. Thank you for listening. Invite you to get back with us again tomorrow. And thank you for being here. I'm Bill O'Brien. This is the Virtual Center for the Study of the Constitution. Please be safe. We want you back with us on another day. Thank you.